Ouzou, je suis professeur de droit public à la faculté de droit de l'Université de Montréal. Cette série de conférences a été établie en 2015 en l'honneur de deux anciens membres de notre faculté. François Chevrette a été professeur de droit public de 1968 à 2012, année de son décès. Entre 1984 et 1988, il a été doyen de cette faculté. Herbert Marx a été professeur de droit constitutionnel de 1969 à 1979, année où il a été élu à l'Assemblée nationale du Québec. Entre 1985 et 1988, il a aussi été ministre de la Justice. En 1989, le professeur Marx a été nommé juge à la Cour supérieure du Québec, fonction qu'il a occupée jusqu'en 2007, année de sa retraite. Le professeur Marx est aux prises avec une pneumonie et malheureusement ne pourra donc être présent parmi nous ce soir. Nous lui souhaitons évidemment le plus prompt des rétablissements. La création des conférences a été rendue possible grâce au soutien des fonds de l'Université de Montréal portant les noms de ces deux constitutionnalistes. Tous les travaux de la conférence sont publiés aux éditions Thémis. Aujourd'hui, nous avons le privilège d'accueillir deux éminents membres de la magistrature. D'abord, notre conférencier principal, le très honorable Lord Juge Singh de la Cour d'appel d'Angleterre et du Pays de Galles, que j'aurai le plaisir de vous présenter. Ensuite, l'honorable juge Chamberland de la Cour d'appel du Québec, qui a gracieusement accepté notre invitation à venir livrer un commentaire sur l'allocution du Lord Juge Singh. Mon co-organisateur, collègue et ami, le professeur Jean Leclerc, vous le présentera plus tard. Rabinder Singh received his first law degree from Trinity College in Cambridge and his Master of Laws from the University of California at Berkeley in 1986, where he matriculated as a Harkness Fellow. Upon returning to the United Kingdom, he took first a lectureship at the University of Nottingham before beginning in 1989 a distinguished career at the bar. Over the next 2 decades, Mr. Singh argued more than 35 cases before the House of Lords, the UK Supreme Court, and the European Court of Human Rights on behalf of the government and non-governmental parties. He was part of the Attorney General's panel of junior counsel to the Crown from 1992 to 2002, as well as additional junior counsel to the Inland Revenue from 1997 to 2002. In 2000, with a group of leading barristers, Mr. Singh co-founded the Matrix Chambers, now one of the UK's most highly regarded sets specialized in public law litigation. He received several awards and distinctions, such as Barrister of the Year in 2001 and Human Rights Lawyer of the Year in 2006. He was made Queen's Counsel in 2002. In 2003, at 39 years old, Rabinder Singh was appointed as a Deputy High Court Judge, becoming the youngest person to sit on the High Court. The following year, he became a Recorder of the Crown Court. Appointed as a Justice of the High Court in 2011, Sir Rabinder has been a presiding judge of the Southeastern Circuit, as well as the liaison judge of the Queen's Bench Division in Wales and the Midland and Western Circuits. In 2017, he was elevated to the Court of Appeal. Sir Rabinder has authored or co-authored 2 books and published several articles in public law and international law. In 2004, he received an honorary doctorate of law from the London Metropolitan University. He was a visiting professor of law at the London School of Economics from 2003 to 2009, and he is now an honorary professor of law at Nottingham University and a visiting fellow at Lady Margaret Hall in Oxford. La conférence de cet après-midi est intitulée « What is a Democratic Society ?» J'ai eu le plaisir de lire une version du texte de l'allocution du Lord Juge Singh. Comme vous ne manquerez pas de le constater, les réflexions de notre conférencier tirent profit de son parcours professionnel remarquable en tant que professeur, praticien et juge. Le temps de quelques années, il a même cumulé les 3 fonctions simultanément. Son propos est particulièrement opportun à plus d'un égard. Ici, au Québec et au Nouveau-Brunswick, où nos campagnes électorales battent leur plein, chez lui, au Royaume-Uni, alors que le régime de protection des droits humains sera ultimement tributaire des termes définitifs de l'accord de sortie de l'Union européenne, et plus généralement dans nos démocraties occidentales, où nos conceptions modernes d'égalité réelle sont mises à l'épreuve. Sans plus tarder, veuillez vous joindre à moi pour accueillir le Lord Juge Singh.
Mesdames et messieurs, bonsoir et merci beaucoup. C'est un grand plaisir à donner cette conférence en honneur de François Chevrette et Herbert Marx. Ils étaient tous les deux savants distingués. Malheureusement, je ne parle pas bien français et donc je vais donner ma conférence en anglais. Section 1 of the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in, quote, a free and democratic society, unquote. The European Convention on Human Rights, many of whose rights have been given effect in domestic law in the United Kingdom by the Human Rights Act 1998, does not have a similar general limitation provision like Section 1 of the Canadian Charter. However, most of the rights set out in the European Convention can, in principle, be limited. The only one which is truly absolute is the prohibition on torture and inhuman or degrading treatment in Article 3. A good example of a limited right in the ECHR can be seen in Article 10, which guarantees the right to freedom of expression and provides that limitations can be placed on that right where this is prescribed by law, again echoing or perhaps anticipating the language of Section 1 of the Charter, and is, quote, necessary in a democratic society, unquote, to achieve one or more of the express aims set out in it, for example, the protection of the rights of others. So both the Canadian Charter and the European Convention make reference to the concept of a democratic society. The question which I want to try to address in my lecture is, what is a democratic society for this purpose? There is a textual difference which exists on the face of Section 1 of the Canadian Charter, which refers to a free and democratic society, and the European Convention, which refers only to a democratic society. I will suggest in this lecture that, in fact, that textual difference in language between the two documents does not make a material difference. The jurisprudence of the European Court of Human Rights makes it clear that it too envisages a democratic society which is also a free society. In the Queen against Oakes in 1986, Chief Justice Dixon famously set out the requirements which must be satisfied before a restriction on a fundamental right in the Charter will be regarded as being reasonable and demonstrably justified. First, the objective of the measure must be sufficiently important to warrant overriding a constitutionally protected right or freedom. Secondly, the measure must satisfy the test of proportionality, which in turn requires an answer to three questions. One, there must be a rational connection between the measure and its objective. Two, the means used should impair the right as little as possible. And three, there must be a proportionality between the effects of the measure on the right in question and the objective which has been identified as of sufficient importance. This principle of proportionality is also very familiar to us in Europe, as it is at the heart of the jurisprudence of the European Court of Human Rights. The questions set out in Oakes are very similar to the ones that courts in the UK have formulated for use under the Human Rights Act. Indeed, the decision in Oakes was very influential in helping us to settle what the relevant questions are for deciding whether a restriction on a fundamental right satisfies the principle of proportionality. See, in particular, the decision in 2007 of the House of Lords in Huang and Secretary of State for the Home Department. In Oakes, Chief Justice Dixon also emphasized the importance of that phrase in Section 1 of the Charter, a free and democratic society. He said, "The court must be guided by the values and principles essential to a free and democratic society, which I believe embody, to name but a few, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society." The underlying values and principles of a free and democratic society are the genesis of the rights and freedoms guaranteed by the Charter, and the ultimate standard against which a limit on a right or freedom must be shown, despite its effect, to be reasonable and demonstrably justified. Similarly, in its seminal jurisprudence of the 1970s, the European Court of Human Rights made it clear that by its vision of a democratic society, it envisages not simply one in which the majority will must prevail. Rather, it is one which is characterized, in the hallowed phrase of that court, by pluralism, tolerance, and broad-mindedness. In Handyside against the United Kingdom in 1976, the court said, "Freedom of expression constitutes one of the essential foundations of such a society," in other words, a democratic society, "one of the basic conditions for its progress and for the development of every man. Subject to Article 10, Paragraph 2, it is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness without which there is no democratic society." In 2012, in giving judgment in a freedom of expression case brought by the BBC in the High Court of England and Wales, I suggested that the words "in a democratic society" in the European Convention are not superfluous. I said, "The framers of the Convention, arising as it did out of the ashes of European conflict in the 1930s and 1940s, recognized that not everything that the state asserts to be necessary will be acceptable in a democratic society." Let me explain what I will endeavor to do in this lecture. I am not a historian, philosopher, or political scientist. I am a lawyer by background and now a judge. The concept of a democratic society is one which is no doubt of interest to historians, philosophers, and political scientists, but they will have a potentially different understanding depending on their discipline. For example, the historian may be interested in the difference between direct democracy, such as that in classical Athens in the age of Pericles, with all its limitations, which are well known, and modern democracy. the right to participate in the affairs of the polis or city-state was limited to adult male citizens, and so it excluded women, slaves, and others. It was a very different kind of democracy from what we know of in the modern era, because the citizens of Athens all met in the ecclesia or assembly to take the most important decisions facing the state. We have become used to the idea of a representative democracy rather than direct participation in the affairs of the state. The philosopher will be interested in what the underlying justification for a democracy is. For example, whether it is based on the principle of the consent of the governed. The political scientist may question whether it is strictly accurate to conceive of a democratic society as including other elements such as liberty and equality. In a very interesting and provocative book published earlier this year, The People versus Democracy, a scholar at Harvard University, Yasha Monk, has suggested that we should no longer necessarily speak of a liberal democratic society, because it is possible for there to be a society which is democratic and yet illiberal. Although he does not approve of the idea, he suggests that it is possible to conceive of a democracy without rights. It may be that the world is now seeing something very different from what it has seen in the past. For example, in the 1920s and 1930s, there was a clear and obvious distinction between what were called democracies and what were called dictatorships. Some 20th century dictators came to power in part by using the ballot box, but then got rid of the institutions of democracy. Today, it is not impossible for a leader to win an election and continue to subject himself to further elections. They do not necessarily want to abolish the basic institutions of democracy in the sense of having elections, but they may be hostile to the concept of fundamental human rights, particularly if those rights are conferred on unpopular minorities. The intellectual historian Professor Sir Larry Siedentop has suggested in his stimulating book, Inventing the Individual, The Origins of Western Liberalism, that the origins of our modern conception of democracy lie in the Christian belief in the equality of all souls. He suggests that in Western philosophy, it was not until Christianity came on the scene that it was considered that all human beings were inherently equal. Before that time, and in particular in classical thinking in ancient Greece and Rome, society was founded on the inherent inequality of human beings based on social status. All of these are valid and interesting viewpoints, but the theme of my lecture will be to ask the question, what is a democratic society from a legal viewpoint? Both the Canadian Charter and the European Convention are legal instruments. It is therefore appropriate to ask what they mean by a democratic society, understood as a legal concept. I will start with something which may be regarded as lying close to the heart of a democracy, that is, the right to vote. Universal adult suffrage was the result of long and sometimes bitter struggle. In the UK this year, we have celebrated the centenary of the extension of the franchise to women, although not all women were given the vote until 1928. In Canada, I understand that women were able to vote in federal elections from 1918, although they had been able to vote in the province of Manitoba from 1916. The right of every Canadian citizen to vote is now guaranteed by Section 3 of the Charter and was described by Chief Justice McLaughlin in Sauvé and Canada as a right which lies at the heart of Canadian democracy. Curiously, the European Convention does not contain an express right to vote, which is conferred on individuals as such. However, that individual right has been held to be implicit in Article 3 of the First Protocol, which provides, I quote, "The high contracting parties undertake to hold free elections at reasonable intervals by secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of the legislature." Because the right to vote lies at the heart of democracy, it might be thought that particularly close scrutiny should be required of any law which denies the right to vote to a certain class of people. In both Canada and the UK, there was at one time legislation which denied the right to vote to all serving prisoners. In Canada, that was held to be unconstitutional by the Supreme Court in Sauvé No. 1 in 1993. The legislation was then amended to disenfranchise only prisoners serving a sentence of 2 years or longer. The amended legislation, set out in Section 51, paragraph E of the Canada Elections Act 1985, was in turn held to be unconstitutional in Sauvé No. 2. In the meantime, in some of the first cases that were brought under the Human Rights Act in the English courts, those courts had held, in a group of cases which included Hearst, that the UK's legislation contained in Section 3 of the Representation of the People Act 1983 was compatible with the rights in the Human Rights Act. In part, this was because the English courts followed what at that time was the decision of the Federal Court of Appeal in Sauvé No. 2, which was later reversed by a narrow majority of 5-4 in the Supreme Court of Canada. The case of Hearst against United Kingdom then proceeded to the European Court of Human Rights in Strasbourg. In Hearst No. 2, in 2006, the European Court of Human Rights held, by a majority of 12-5, the minority including the then president of the court, Judge Wildhaber, that the UK legislation was incompatible with Article 3 of the First Protocol. This was essentially because the legislation contained a complete ban which applied to all serving prisoners, irrespective of the length of sentence or any other characteristic of the individual prisoner. This was therefore held to be disproportionate. The court noted that the decision in Sauvé No. 2 in the Federal Court of Appeal had later been overturned by the Supreme Court of Canada. The court stated that although the margin of appreciation afforded to contracting states in this field is wide, it is not all-embracing. It said, such a general, automatic, and indiscriminate restriction on a vitally important convention right must be seen as falling outside any acceptable margin of appreciation, however wide that margin might be. The decision in Hearst has proved extremely controversial, particularly in British society and in Parliament. Uniquely in my experience, and I should say that I acted as counsel for the government of the UK in Hearst, the judgment of the court was not implemented quickly. In fact, it has taken over a decade for the practice in the UK to be amended. A number of later court cases have been brought both in the domestic courts of the UK and in Strasbourg. In December 2017, the UK government published proposals which the Council of Europe has said that, if implemented, would be sufficient to signify compliance with the judgment in Hearst. Even now, the proposed changes are administrative only and not legislative. They were announced by the Secretary of State for Justice to the House of Commons on the 2nd of November last year. He said, first, the government would work with the judiciary to make it clear to criminals when they are sentenced that while they are in prison, they will lose the right to vote. That directly addresses a specific concern of the judgment in Hearst that there was not sufficient clarity in confirming to offenders that they could not vote whilst in prison. Secondly, the government will amend guidance to address an anomaly where offenders who are released back in the community on license using an electronic tag under what's called the Home Detention Curfew Scheme can vote, but those in the community on temporary license cannot vote. Release on temporary license would not be granted in order to enable a prisoner to vote. In its meeting of the 5th to the 7th of December 2017, the Committee of Ministers of the Council of Europe, which is the body charged with the function of supervising the compliance by contracting states with judgments of the European Court, concluded that overall these measures are an effective package to ensure compliance with the Hearst group of judgments. The government of the UK intend to implement the proposed changes by the end of 2018 and have agreed to report back to the Committee of Ministers this month, September 2018. I turn to another topic, the right to freedom of expression. My next suggestion will be that apart from the right to vote, there are other rights which are essential to the healthy functioning of a democratic society. The most important of these is the right to freedom of expression. As Lord Steyn put it in the Queen and Secretary of State for the Home Department ex parte Sims in 2000, I quote, "In a democracy, it is the primary right. Without it, an effective rule of law is not possible." He went on to describe freedom of speech as the lifeblood of democracy. He said, "The free flow of information and ideas informs political debate. It acts as a brake on the abuse of power by public officials. It facilitates the exposure of errors in the governance and administration of justice of the country." However, as Lord Steyn went on to say in Sims itself, not all types of speech have an equal value. For example, he said, no prisoner would ever be permitted to have interviews with a journalist, to publish pornographic material, or to give vent to so-called hate speech. Sims was decided just before the Human Rights Act came into force in the UK. Now, the right to freedom of expression is guaranteed by Article 10 of the European Convention through the Human Rights Act. In Canada, the right to freedom of expression is guaranteed by Section 2, Paragraph B of the Charter. However, it is also to be noted that there is an equality provision in Section 15(1) of the Charter, which provides that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national and ethnic origin, colour, religion, sex, age, or mental or physical disability. Furthermore, Section 27 of the Charter provides that it shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians. In the UK, we do not have any statutory provision like Article 27 of the Charter. We do have an equality provision in Article 14 of the ECHR. Although Article 14 is not a freestanding provision, like Section 15 of the Canadian Charter, it does guarantee equal treatment in the enjoyment of other convention rights. The 12th Protocol to the ECHR does contain a freestanding right to equal treatment, but that has not been ratified by the UK. In both Canada and the UK, there are criminal laws prohibiting the propagation of hate speech, particularly speech which is directed at certain groups in society defined by reference to race or religion. In the UK, at least, such laws had their origins in concern about public disorder. For example, the Public Order Act 1936, enacted at a time when the British Union of Fascists was active, and that act later being amended to include incitement to racial hatred, by the Race Relations Act 1976. More recently, in 2006, Parliament has prohibited speech which is likely to incite religious hatred. In Canada, the compatibility of legislation prohibiting hate speech, Section 319 of the Criminal Code, was considered by the Supreme Court in the Queen against Keegstra in 1990. The law was upheld by a majority of 4-3. The majority judgment was given by Chief Justice Dickson. The Supreme Court considered that in principle, Section 319(2) of the Canadian Criminal Code did constitute an infringement of the Charter guarantee of freedom of expression. Accordingly, the crucial question was whether that infringement could be justified under Section 1 of the Charter as a reasonable limit in a free and democratic society. The Chief Justice said, I quote, "A practical application of Section 1 requires more than an incantation of the words free and democratic society. These words require some definition and elucidation as to the values that they invoke. To a large extent, a free and democratic society embraces the very values and principles which Canadians have sought to protect and further by entrenching specific rights and freedoms in the Constitution, although the balancing exercise in Section 1 is not restricted to values expressly set out in the Charter." Chief Justice Dickson identified two sorts of injury which are caused by hate propaganda. This went beyond mere offensiveness. As I have mentioned, the European Court of Human Rights has frequently said that the right to freedom of expression includes the right not only to express ideas which are found to be acceptable by others in society, but also to say things which may cause offense. However, as Chief Justice Dickson said in Keegstra, hate propaganda goes beyond mere giving of offense and causes real harm. First, there is harm done to members of the target group. Again, I quote, "It is indisputable that the emotional damage caused by words may be of grave psychological and social consequence. In the context of sexual harassment, this court has found that words can in themselves constitute harassment. In a similar manner, words and writings that willfully promote hatred can constitute a serious attack on persons belonging to a racial or religious group. And in this regard, the Cohen Committee noted that these persons are humiliated and degraded. In my opinion, a response of humiliation and degradation from an individual targeted by hate propaganda is to be expected. A person's sense of human dignity and belonging to the community at large is closely linked to the concern and respect accorded the groups to which he or she belongs. The division, hostility, and abuse encouraged by hate propaganda therefore have a severely negative impact on the individual's sense of self-worth and acceptance. Such consequences bear heavily in a nation that prides itself on tolerance and the fostering of human dignity through, among other things, respect for the many racial, religious, and cultural groups in our society." Chief Justice Dickson said that a second harmful effect of hate propaganda is its influence upon society at large. After referring to the experience of the 20th century, which had shaken faith in earlier Enlightenment views about the rationality of humankind, he said, "It is thus not inconceivable that the active dissemination of hate propaganda can attract individuals to its cause and in the process create serious discord between various cultural groups in society." He went on to say, "The threat to the self-dignity of target group members is thus matched by the possibility that prejudiced messages will gain some credence, with the attendant result of discrimination and perhaps even violence against minority groups in Canadian society." The Chief Justice also noted that international human rights instruments support Canadian, and I would suggest British, policy in this context. Article 4 of the United Nations Convention on the Elimination of All Forms of Racial Discrimination of 1966, sometimes given the acronym CERD or CERD, is of special interest. It provides, quote, states parties condemn all propaganda and all organizations which are based on ideas or theories of superiority of one race or group of persons of one color or ethnic origin, or which attempt to justify or promote racial hatred and discrimination in any form, and undertake to adopt immediate and positive measures designed to eradicate all incitement to or acts of such discrimination, and to this end shall declare an offense punishable by law all dissemination of ideas based on racial superiority or hatred, incitement to racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of persons of another color or ethnic origin. Chief Justice Dixon also noted that the 1966 International Covenant on Civil and Political Rights, which guarantees the right to freedom of expression in Article 19, goes on in Article 20, paragraph 2 to state, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Chief Justice Dixon then turned to the heart of the dispute in Keegstra itself. He noted the particular link with the political rationale for protection of freedom of expression in a democracy. He said, freedom of expression is a crucial aspect of the democratic commitment, not merely because it permits the best policies to be chosen from among a wide variety of proffered options, but additionally because it helps to ensure that participation in the political process is open to all persons. Such open participation must involve, to a substantial degree, the notion that all persons are equally deserving of respect and dignity. Chief Justice Dixon recognized that suppression of hate propaganda undeniably muzzles the participation of a few individuals in the democratic process, but he considered the degree of that limitation not substantial. He went on to say that hate propaganda can work to undermine our commitment to democracy when employed to propagate ideas which he described as anathemic to democratic values. I quote, hate propaganda works in just such a way, arguing as it does, for a society in which the democratic process is subverted and individuals are denied respect and dignity simply because of racial or religious characteristics. This brand of expressive activity is thus wholly inimical to the democratic aspirations of the free expression guarantee. In a very important passage, in my view, Chief Justice Dixon went on to state, I am very reluctant to attach anything but the highest importance to expression relevant to political matters. But given the unparalleled vigor with which hate propaganda repudiates and undermines democratic values, and in particular its condemnation of the view that all citizens need to be treated with equal respect and dignity, so as to make participation in the political process meaningful, I am unable to see the protection of such expression as integral to the democratic ideal, so central to the Section 2B rationale. In the context of the European Convention, it is worth noting that Article 17 itself contains a provision designed to prevent abuse of the rights set out in it. It says, nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein, or at their limitation to a greater extent than is provided for in the Convention. The position in both Canada and the UK can be contrasted with the starkly different approach which has been taken by the Supreme Court of the United States, for example, in RAV versus City of St. Paul, Minnesota in 1992. This is no doubt because of the very strict nature of the First Amendment guarantee of free speech in the US. I would suggest, as Chief Justice Dixon did in Keegstra, that the underlying value which is protected by laws against hate speech is the right to equality. In a British case, A against Secretary of State for the Home Department in 2005, often known in the UK as the Belmarsh case, Lord Bingham quoted Professor, later Sir Hersch Lauterpacht, in his seminal work, An International Bill of the Rights of Man, published in 1945, when Lauterpacht said, "The claim to equality before the law is, in a substantial sense, the most fundamental of the rights of man." Lord Bingham then went on to observe that in the Privy Council, in Matadine and Pointu, 1999, Lord Hoffman had said, with reference to the principle of equality, "Such a principle is one of the building blocks of democracy and necessarily permeates any democratic constitution." In a more recent case under the Human Rights Act, Gaydan against Godin Mendoza in 2004, Baroness Hale said this: "Such a guarantee of equal treatment is also essential to democracy. Democracy is founded on the principle that each individual has equal value. It is a purpose of all human rights instruments to secure the protection of the essential rights of members of minority groups, even when they are unpopular with the majority." And in possibly the most famous sentence which has been crafted to date by a judge in the UK on the Human Rights Act, Baroness Hale said this: "Democracy values everyone equally, even if the majority does not." In that important passage, I would suggest, lies the key to an understanding of the legal concept of a democratic society. The reason why we value democracy is precisely because it is founded on the inherent equality of every participant in it. This is why everyone in a democracy has the right to vote, but no one has more than one vote. That was not always the case in the UK. At one time, until as recently as the end of the Second World War, people who were graduates of one of the so-called ancient universities could vote more than once, both in the constituency where they lived and, secondly, for a member of parliament who represented their former university. In theory, at least, it is not impossible to conceive of a society in which people might be given more votes depending on their wealth or social status. It might be said that someone who pays more in taxation should have more votes than a person who pays little into the state's coffers. Such ideas seem fanciful and indeed wrong to us now. This is because I would suggest, at its root, democracy is properly considered to be a system in which everyone counts, but no one counts more than anyone else. This is the fundamental idea of equality. When, therefore, one member of society abuses their right to freedom of expression, to deny the right of another member of society to participate on an equal basis in a democracy, as in the case of hate speech, this could be regarded as striking at the very heart of what a democracy is. And I want to turn to a different topic now, the rights of minorities and what might be called the rights of a minority within a minority. In the Belmarsh case, Baroness Hale, who is now the President of the Supreme Court of the UK, quoted Thomas Jefferson in his inaugural address on becoming President of the US in 1801. He said, "Though the will of the majority is in all cases to prevail, that will to be rightful must be reasonable. The minority possess their equal rights, which equal law must protect, and to violate would be oppression." She added in her own words, "Democracy values each person equally. In most respects, this means that the will of the majority must prevail. But valuing each person equally also means that the will of the majority cannot prevail if it is inconsistent with the equal rights of minorities." In the last year, I have sat in 2 cases as a judge in which this issue of the protection of the rights of minorities has arisen in a stark way. The first case was in the Divisional Court, which is part of the High Court of England and Wales, in which I sat with Mrs. Justice Whipple, the Queen on the application of Adath Yisrael Burial Society and Her Majesty's Coroner for Inner North London. That case concerned a policy which was adopted by a coroner not to take into account the religious views, for example, of Jewish or Muslim people, that their cases should be dealt with urgently because they felt there was a need to bury a loved one quickly and, if possible, on the day of death. The policy was described as a cab rank principle. In other words, that every case would be dealt with in the order in which it was notified to the coroner's office. We held that the policy was unlawful on a number of grounds, including a breach of the right to freedom of religion in Article 9 of the European Convention and the right to equal treatment in Article 14. That did not mean that members of a religious minority, such as Jewish or Muslim people, always had to be given priority, because there may be other legitimate demands on a coroner's time and resources. But it did mean that there could not be a policy that their needs would never be taken into account. The principle of proportionality had to be complied with. We quoted Lord Steyn from a paper he gave in 2001 when he said, "It is a fundamental tenet of democracy that both law and government accord every individual equal concern and respect for their welfare and dignity." That phrase, equal concern and respect, echoes the central thesis in the writings of the late Professor Ronald Dworkin. In our judgment, we added that the kind of society which is envisaged by the Convention and the Human Rights Act is one which is based on respect for everyone's fundamental rights on an equal basis. It regards democracy as being a community of equals. In our judgment, we observed that it would be a mistake to think that having a cab rank policy will always lead to everyone being treated equally. We said, what on its face looks like a general policy which applies to everyone equally may in fact have an unequal impact on a minority. In other words, to treat everyone in the same way is not necessarily to treat them equally. Uniformity is not the same thing as equality. The second case that I would like to mention in this context is In Re A Children, Contact Ultra-Orthodox Judaism, Transgender Parent, which was decided by the Court of Appeal of England and Wales last December. I was a member of the court, which included Lady Justice Arden, who will shortly become a Justice of the Supreme Court, and was presided over by Sir James Mumby, who was then President of the Family Division, in other words, the most senior family law judge in our jurisdiction. He gave the judgment of the court. The case concerned the right of a male to female transgender person to have direct contact with her children in circumstances when the family's community, which was an ultra-Orthodox Jewish community, said that it would ostracize the entire family if there was such contact. Such ostracism would have had a detrimental effect on the welfare of the children. But the consequence of the alternative course of action was that the children would no longer have direct contact with their natural father. We allowed the appeal and remitted the case to the High Court for further consideration to be given to whether it was possible to promote contact, judging the children's welfare by the contemporary standards of society. The court said, "The function of the judge in a case like this is to act as the judicial reasonable parent, judging the child's welfare by the standards of reasonable men and women today, having regard to the ever-changing nature of our world, including changes in social attitudes, and always remembering that the reasonable man or woman is receptive to change, broad-minded, tolerant, easygoing, and slow to condemn. We live in a democratic society subject to the rule of law. We live in a society whose law requires people to be treated equally and where their human rights are respected. We live in a plural society in which the family takes many forms, some of which would have been thought inconceivable well within living memory. We were acutely conscious that the case concerned not only the rights of the children or the rights of a transgender person, but also the rights of a religious minority to live their lives in accordance with their sincerely held beliefs. However, we recalled that it is well established on authority that discrimination which is motivated by a religious belief, however sincerely held, and even if the discrimination is mandated by that religious belief, does not make discrimination under the Equality Act lawful. Both of the recent cases I have mentioned raise in an acute way sensitive issues about the balance which needs to be struck in a democratic society between the rights of individuals and minority groups on the one hand and the rights of the majority on the other. There may indeed also be a tension between the rights of an individual within a religious minority group, such as a transgender person, and the rights of others in that group. The courts in both Canada and the UK have no choice but to grapple with such sensitive issues when they are brought before them by litigants. This leads me on to my final point: the relationship between the elected institutions in a democracy and the courts. This was addressed by Lord Bingham in the Belmarsh case in the following way. He said, "I do not accept the full breadth of the Attorney General's submissions. I do not in particular accept the distinction which he drew between democratic institutions and the courts. It is, of course, true that the judges in this country are not elected and are not answerable to Parliament. It is, of course, also true that Parliament, the executive, and the courts have different functions. But the function of independent judges charged to interpret and apply the law is universally recognized as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. The Attorney General is fully entitled to insist on the proper limits of judicial authority, but he is wrong to stigmatize judicial decision-making as in some way undemocratic." Lord Bingham concluded, "The Human Rights Act gives the courts a very specific, wholly democratic mandate." By way of conclusion, let me try to draw together the threads of my theme in this lecture. I would suggest that the sort of democratic society which is envisaged by a human rights charter is not one which can be based simply on the notion of majority rule, but rather is one which is based on the three fundamentals of liberty, equality, and fraternity, the last of those perhaps now better expressed as community. We no longer conceive of fundamental rights as belonging to atomized individuals living in a state of nature. Rather, they exist within the framework of an organized community. Indeed, they often depend on the community for their protection and full enjoyment. This is one reason why there can be limitations placed on a fundamental right, provided the limitation is objectively justified and satisfies the principle of proportionality. But I would suggest that a democratic society is a community of equals. The concept of democracy itself is founded on the basic value of human equality. And finally, a democratic society is one in which there are independent courts entrusted with the task of the protection of fundamental rights, including the rights of individuals and minority groups, even if they are unpopular with the majority. In the words of the oath of office, which every judge in England and Wales has to take, the courts will protect those rights without fear or favour, affection or ill will. What all of this indicates is that a democratic society is not only one in which the people elect their government, it is also a community in which everyone enjoys fundamental human rights on an equal basis and in which those rights are enforceable in independent courts. Thank you.
Thank you very much, Lord Justice Singh, for this very stimulating lecture. I hope you will not mind my presenting our next speaker in French. La démocratie est en crise, comme le disait déjà en 2007 l'historien philosophe Marcel Gauchet, spécialiste de l'histoire de la démocratie. Cet auteur déplorait alors que le respect des droits de la personne en soit venu à remplacer l'engagement politique citoyen comme critère premier de définition de la démocratie. Respecter les droits de la personne serait aujourd'hui, dit-il, le nec plus ultra de l'expression démocratique. On aboutirait alors, pour reprendre la formule du philosophe politique Pierre Manant, à une démocratie sans peuple. Le droit aurait donc chassé le politique. On constate aussi qu'un grand nombre de personnes semblent aujourd'hui préférer la démocratie comme mécanisme de décision à la démocratie comme mécanisme de délibération publique et de justification. Le référendum sur le Brexit en est un bel exemple. On vote pour trancher le débat en invoquant le principe démocratique, mais on réalise trop tard que celui-ci suppose un échange d'idées sur des enjeux complexes qui se prêtent mal aux postures manichéennes. L'aplatissement du principe démocratique au seul respect des droits et libertés individuelles et à un simple mécanisme décisionnel n'est pas sans remède. Je pense que Lord Justice Singh a démontré qu'il faut nuancer les propos de Gauchet et Manant. Des droits individuels garantis par une magistrature indépendante jouent un rôle important dans le fonctionnement d'une démocratie comme la nôtre. Et il prend soin de rappeler que les fundamental rights exist within the framework of an organized community and that they depend on the community for their protection and full enjoyment. Mais il est un autre moyen de raffermir le tissu démocratique. Et il passe par la revalorisation du politique lui-même, en tant que lieu de la transcendance par les citoyens eux-mêmes, de leurs intérêts particuliers au profit de choix collectifs légitimes. Comme le disait le juge Brandeis dans sa célèbre opinion concordante dans l'arrêt Whitney versus California en 1927, « The greatest menace to freedom is an inert people ». Or, pour qu'une personne puisse soumettre son propre jugement ou sa propre volonté à l'intérêt de la collectivité, encore faut-il pouvoir la convaincre. Il importe donc d'assurer la liberté d'expression de tous, puisque sans elle, l'engagement politique citoyen est impossible. Lord Justice Singh a déjà abordé l'enjeu représenté par cette liberté dans une démocratie. Mais pour assurer un engagement citoyen informé, il faut également que soit garantie une pleine liberté de presse. Or, c'est de cela précisément que nous entretiendra notre distingué invité, l'honorable juge Jacques Chamberland. Le juge Chamberland est le juge doyen de la Cour d'appel du Québec, dont il est membre depuis 25 ans. Diplômé magna cum laude de la faculté de droit de l'Université de Montréal en 1971, où il a eu François Chevrette pour professeur, il a d'abord exercé le droit en pratique privée, avant de devenir sous-ministre de la Justice et sous-procureur général du Québec en 1988, alors même qu'Herbert Marx, qui n'est malheureusement pas parmi nous ce soir, était ministre de la Justice. En sa qualité de sous-ministre, M. Chamberland a pris une part active dans la réforme du Code civil du Québec et il était titulaire de cette fonction lors d'événements marquants pour le Québec, tels la négociation et l'échec de l'accord de Charlottetown ou la crise d'Oka. Après avoir accédé à la Cour d'appel en 1993, le juge Chamberland a été désigné par le Canada pour participer aux travaux de la Conférence de La Haye en droit international privé, tout spécialement sur l'enlèvement d'enfants, et les questions familiales transfrontalières. Il collabore toujours aux travaux de la Conférence de La Haye en droit international privé et jusqu'à tout récemment, il était l'un des 2 juges canadiens membres du réseau international des juges de La Haye. Entre autres activités en marge de la Cour d'appel, M. Chamberland a aussi présidé, à compter de septembre 2000 et jusqu'en juin 2010, le comité d'éthique de la recherche de l'Institut de recherche clinique de Montréal, ce qui lui a valu de recevoir, le 10 novembre 2010, la médaille du mérite de cet institut. Enfin, et il importe de le souligner en raison de ce qu'il entend aujourd'hui aborder devant nous, de novembre 2016 à décembre 2017, le juge Chamberland a présidé la commission d'enquête sur la protection de la confidentialité des sources journalistiques, dont le rapport a été déposé le 14 décembre 2017. Il a depuis repris ses fonctions de juge à la Cour d'appel et poursuit son implication dans les travaux de la Conférence de La Haye de droit international privé et de l'International Advisory Council auprès des cours de justice familiale de Singapour. La faculté de droit de l'Université de Montréal reconnaît en lui l'un de ses plus brillants diplômés, qui a contribué de nombreuses façons à l'avancement du droit et qui laissera une marque durable sur la jurisprudence canadienne et québécoise. Je vous prie d'accueillir M. le juge Chamberland.
Merci pour vos bons mots, professeur Leclerc, et merci à vous et au professeur Zhu pour cette aimable invitation. C'est un immense privilège de partager cette tribune avec un collègue aussi savant et distingué que Lord Justice Rabinder Singh. Throughout the years, having had the good fortune of working with the Hague Conference on Private International Law, particularly in the field of cross-border parental-child abduction, I have met a number of judges from the Court of Appeal of England and Wales. The names of Elizabeth Butler-Sloss, Brenda Hale, Baroness Hale, Jill Black, now a puisne judge on the Supreme Court, Matthew Thorpe, and Andrew Moylan come to mind. They are all highly eminent jurists with whom I had pleasure working over the years and enjoying their friendship. Lord Justice Singh is made out of the same cloth, and I feel honored and privileged to be here with him today. Mon plaisir d'être sur la montagne, ici, à l'Université de Montréal, où le regretté est d'autant plus grand que j'y ai suivi des cours du professeur François Chevrette en droit constitutionnel à la fin des années 60, début des années 70. François Chevrette était un professeur très chaleureux avec ses étudiants. Je vois Daniel Chénard ici, certainement sûrement d'accord avec moi. Et c'était la belle époque pour les étudiants en droit constitutionnel, puisque le droit constitutionnel, à cette époque, se limitait essentiellement au problème de partage de compétences entre le gouvernement fédéral et les provinces. Et la quasi-totalité des arrêts pertinents tenait dans 3 volumes assemblés par Richard Olmsted, QC. Herbert Marx ne m'a pas enseigné le droit constitutionnel, mais il était le ministre de la Justice lorsque je suis devenu sous-ministre en avril 1988. C'est lui qui m'a accueilli au ministère et guidé alors que j'y faisais mes premiers pas. C'est à l'époque de la politique tolérance zéro en matière de violence conjugale, de la réforme de la procédure pénale et de la création de la Cour du Québec, pour ne nommer que ces 3 grands chantiers. Herbert Marx était un homme d'idées, progressiste et un brin marxiste, comme il le dit lui-même à la blague. Je garde un excellent souvenir de notre trop court partenariat. On November 22, 2016, 2 weeks after the election of the 45th President of the United States of America, CNN's chief international correspondent, Christiane Amanpour, was in New York City to receive an award for a sustained achievement in the cause of freedom of the press. In her acceptance speech, she invited her colleagues journalists to stand up and fight for their profession, for their values, and for what is right in a world in which, and I quote, journalism and democracy are in mortal peril, and where bad things do happen when good people do nothing. On August 16 last, as a long delayed echo to this speech, more than 400 U.S. news outlets joined in running editorials in response to 45, calling the press the enemy of the people, some of the editorials referring to the president's rhetoric as being, and I quote, right out of the authoritarianism playbook, end of quotation. And now, Bob Woodward's book, Fear, Trump in the White House, to be released on September 11. Chilling, is it not? And all of this is unfolding just south of our border. So what is a democratic society? Justice Singh concludes his lecture by suggesting that a democratic society is a community of equals, the concept of democracy itself being founded on the basic value of human equality. It is also one in which there are independent courts entrusted with the task of protecting our fundamental rights and freedoms. Justice Singh has, in my view, most eloquently captured the essence of democracy, focusing on 4 key notions in any liberal democratic society: the right to vote, the freedom of expression, the protection of the rights of minorities, and finally, the relationship between the elected institutions and the courts. For my part, I will draw on my recent experience at the Commission of Inquiry on the Protection of the Confidentiality of Journalistic Sources to illustrate the role of the courts, and especially that of the Supreme Court of Canada, in defining the contours of the protection of the freedom of the press in this country. I will also take this example to show that the responsibility to protect our rights and freedoms is a shared one, the contribution of the other branches of government being as essential as that of the judiciary. In Schweitzman versus Elbling, a 1957 decision, 25 years before the Canadian Charter of Human Rights and Freedom, the Supreme Court considered the constitutional validity of an act to protect the province against communistic propaganda, also known as the Padlock Act, adopted years before when Maurice Duplessis was the Premier of Quebec. Mr. Duplessis was known to have very little patience for his political opponents or for those who did not think like him. The express object of the Padlock Act was to put an end to communism in this province, thus making it, and I quote, unlawful to print, to publish in any manner whatsoever, or to distribute in the province any newspaper, periodical, pamphlet, circular, document, or writing whatsoever, propagating or tending to propagate communism or Bolshevism. In an 8-1 decision, the Supreme Court declared the act unconstitutional. 5 judges concluded that it was a legislation in respect of criminal law, a matter falling under the exclusive constitutional jurisdiction of the Parliament of Canada. But 3 judges went further, however, concluding that it also amounted to an unjustifiable interference with the freedom of expression. Writing for this group of judges, Justice Rand wrote, and I quote, "Whatever the deficiencies in its workings, Canadian government is in substance the will of the majority expressed directly or indirectly through popular assemblies. Parliamentary government postulates a capacity in men acting freely and under self-restraints to govern themselves. Liberty in this is little less vital to man's mind and spirit than breathing is to its physical existence." The freedom of the press is expressly protected in Canada as part of the freedom of expression. No right or freedom is absolute, not even one as fundamental as freedom of expression. In this context, the role of the judiciary in defining the contours of the protection of the freedom of the press was and still is of signal importance. The first post-charter decision of the Supreme Court based on the freedom of the press provision, the Charter, came in 1988. It was followed by many others dealing with the same issue from different angles. I will focus my attention here on 3 of these angles: publication bans, search warrants, and the confidentiality of journalistic sources. Essential to journalism is the gathering of information, and after analysis, its publication or dissemination. It is not surprising to find a large number of decisions dealing with situations where the right of a journalist to have access to information or to publish it was challenged. In the 1988 Canadian Newspapers Company decision, a complainant in a sexual assault case applied to the courts for an order under the Criminal Code directing that her identity not be published in any newspaper or broadcast. The Supreme Court ruled in her favor, concluding that the publication ban constituted a reasonable and justifiable limit to the freedom of the press, in that it purported to foster complaints by victims of sexual assault by protecting them from the trauma of widespread publication, resulting in embarrassment and humiliation for them. The objective was of sufficient importance to warrant overriding a constitutional right, and it imposed, according to the Supreme Court, only minimal limits on the rights of the media. But the milestone decision concerning publication bans came in 1994 in the Dagenet versus CBC case. Pursuant to an application by 4 members of a Catholic religious order, all of whom had been charged with physical and sexual abuse of young boys in their care, the CBC was enjoined from broadcasting a fictional miniseries about abuse of children. In a split decision, 6-3, the Supreme Court ruled in favor of the CBC, proposing a new approach to assessing whether a publication ban should be ordered. The idea being to balance both the right to a fair trial and the freedom of expression, rather than enshrining one, the former, at the expense of the other, the latter, as went the reasoning in the past. A publication ban should only be ordered when A, such a ban is necessary to prevent a real and substantial risk to the fairness of the trial, and B, the salutary effects of the publication ban outweigh the deleterious effects to the free expression of those affected by the ban. The test was slightly modified in 2001 in Regina versus Mentock in order for it to accommodate orders that must occasionally be made in the interest of the administration of justice, a concept that goes well beyond the right to a fair trial. The test is now known as the Dagenet-Mentock test. It applies to all discretionary court orders that limit freedom of the press in relation to legal proceedings, but it does not apply, however, to mandatory bans. that is, when the ban on any disclosure of information is beyond the discretion of the judge, for example, where the existence of a police informer privilege has been established. One final decision is of note on this topic, that of Bragg Communications in 2012. There, the Supreme Court ruled that despite the critical importance of the open court principle and of a free press in a democratic society, there were cases where the protection of social values, not charter values, social values, although they can coincide, I suppose, but social values must prevail over openness. Here, the privacy interests of a 15-year-old girl and the protection of children from cyberbullying. The Supreme Court authorized the young girl to proceed anonymously in her application for an order requiring an internet provider to disclose the identity of the person behind the IP address used to publish a fake Facebook profile using her picture. Also essential to journalism is in the gathering of information is for the media not to be perceived as collaborating directly or indirectly with the police forces and the judicial system. The reasoning being that this essential function, gathering the information, could be seriously inhibited if the police had too ready access to information in the hands of the media. Late in 1991, the Supreme Court rendered two decisions that had a significant impact on the work of journalists and police forces across Canada. CBC versus Lessard and CBC versus Attorney General for New Brunswick. In both cases, the police sought judicial authorization to search for videotapes on CBC's premises. Acknowledging the vitally important role of the media in the functioning of a democratic society, the Supreme Court listed a number of factors, 9 in all, that must be taken into consideration in determining whether a warrant should be issued for the search of media premises. 3 of these factors are of a particular importance. 1, ensuring that a balance is struck between the interests of the state in the investigation and prosecution of crimes and the right to privacy of the media in the course of their news gathering and news dissemination function. 2, the application for the search warrant should, quote unquote, ordinarily disclose, not always, ordinarily disclose whether there are alternative sources from which the information may reasonably be obtained. And 3, if a warrant is to be issued, consideration should be given to the imposition of conditions on its implementation, so that the media organization will not be unduly impeded in the publishing or dissemination of the news. In both cases, the Supreme Court accepted the idea that the freedom to publish news necessarily encompasses that to gather the information. These decisions paved the way for 2 judgments of the Supreme Court that came almost 20 years later in 2010, acknowledging that an important element in the news gathering function of the media is for the journalist, especially in the investigative type of journalism, to make use of confidential sources of information. I was going to say something I won't, referring to the New York Times, but okay, in the National Post case, that's May 2010, in its effort to identify the author of a forged document transmitted by a confidential source to a journalist, of course in a plain brown envelope, the RCMP obtained a warrant and assistance order directing the editor-in-chief of the National Post to assist in locating the documents and to make them available for forensic analysis, DNA, fingerprints, and the like. An issue before the Supreme Court where the media claimed to protect the identity of their confidential sources, the public interest in freedom of the press and freedom of expression, and finally, the public's right to every person's evidence in the investigation and punishment of crimes. The Supreme Court opted for a case-by-case model of privilege to characterize the media claim to protect the identity of their confidential sources of information. The analysis to be made in accordance with the 4-pronged test proposed by Professor Gmickmore 1, the communication must originate in a confidence that the identity of the informant will not be disclosed. 2, the confidence must be essential to the relationship in which the communication arises. 3, the relationship must be one which should be sedulously fostered in the public good. Sedulously is not a word from me, it's a word from Professor Wigmore. If you look in the dictionary, it means diligently, deliberately, and consciously. And close parenthesis. And the fourth part of the test is whether, in the instant case, the public interest served by protecting the identity of the informant from disclosure outweighs the public interest at getting at the truth, the burden of proof lying on the journalist and the media. In this instance, the court held that the warrant and assistance order were valid. In the Globe and Mail case, October 2010, the context was that of a civil litigation. The media brought a motion to quash different orders requiring that several employees of the federal government answer questions deliberately aimed at identifying a confidential source of information then known as Machouette. The Supreme Court concluded that there was a basis in the laws of Quebec for a journalistic confidential source privilege, and that the use of a Wigmore-like framework was totally relevant for litigation subject, or civil litigation to make it shorter, despite the common law origins of the Wigmore test. So, by the end of 2010, these decisions that I referred to, and many others, had defined the contours of the protection of the freedom of the press in a variety of contexts. In a society where no right or freedom is absolute, and where, in the end, the limits of a right are often defined in relation to those of other rights. Then came the autumn of 2016. On September 22, we all learned that the Sûreté du Québec, that's the National Police Force in Quebec, had seized the computer of a journalist at the Montreal courthouse. Concerns were immediately raised as to the confidentiality of the material contained in the computer. On the same day, the Quebec National Assembly adopted a resolution supporting the importance of protecting journalistic sources. A month later, we learned that another journalist had been under surveillance, this time by the Montreal Police Department, the investigators having had access to his telephone records for a long period of time. The media immediately and unanimously denounced an attack on the freedom of the press and on the right of the public to the information. Doubt was cast on the role allegedly played by certain politicians in the launching of these investigations. Doubt was also cast on the role of the judiciary in the issuance of these warrants. Politicians, both at the provincial and federal levels, were quick to react. The government of Quebec immediately launched a commission of public inquiry to look into the situation and make recommendations, among other things, as to what could be done to better protect the confidentiality of journalistic sources, with the report due for March 1st, 2018. At the federal level, Senator Carignan introduced Bill S-231 before the Senate, an act to amend the Canada Evidence Act and the Criminal Code, its object being to enhance the protection of journalistic sources. It was readily adopted by the Senate and then, in a matter of weeks, in the fall 2017, by the House of Commons in Ottawa. The Act provides that any warrant, authorization, or order relating to a journalist's communications or to an object, document, or data relating to or in the possession of a journalist may be issued only if two conditions. A, there is no other means by which the information can reasonably be obtained, and B, the public interest in the investigation and prosecution of a criminal offense outweighs the journalist's right to privacy in gathering and disseminating information. These conditions are directly inspired by 1991 Lessard and New Brunswick decision. The Act also allows journalists not to disclose information or a document that identifies or is likely to identify a confidential source of information unless, again, two conditions: A, the information or the document cannot be obtained by any other reasonable means, and B, the public interest in the administration of justice outweighs the public interest in preserving the confidentiality of the journalistic sources. Having regard to such considerations, they're listed in the Act, helpful for the judge in passing, having regard to such considerations as the importance of the information or document to a central issue in the proceedings, the freedom of the press, and the impact of the disclosure on the source and the journalist. This rule of evidence is largely inspired by the 2010 National Post and Globe and Mail decisions, with one significant exception: the burden of convincing the court that the information should be disclosed rests with the person requesting disclosure, contrary to what the Supreme Court had ruled when looking at the problem from the perspective of an exception to the public's right to every person's evidence, or to the obligation of a witness to testify. This new rule of evidence aimed at protecting the identity of journalistic sources is already before the courts, in the context of a series of accusations launched in 2016 against 6 persons, including 2 former ministers of the Quebec government. The persons accused want to force 2 journalists to testify and reveal. The 2 journalists are now down to 1, but 2 at the when they started the proceedings. They want the 2 journalists to testify and reveal the identity of their confidential sources of information in the context of a motion for a stay of proceedings, grounded on the fact that a large number of confidential documents and information from the criminal investigation had found their way into the hands of journalists who published them. The matter is currently pending before the Supreme Court of Canada, leave to appeal having been granted on August 9 last, and the hearing being set for December 12 of this year. The Commission of Inquiry on the Protection of the Confidentiality of Journalistic Sources filed its report with the Quebec government on December 14, 2017. Our recommendations, 27 in all, were presented in the form of 2 key recommendations, one on the protection of journalistic material and sources. So the word material is important. It goes beyond the sources. It's all the material and source, plus the sources. And the other on the relationship between politicians and the police, followed by a series of supplementary recommendations under different related themes. The Commission's key recommendation number 1 was to propose the enactment of a Journalistic Material and Sources Protection Act, the objective being to gather all the elements of a comprehensive regime of immunity for journalists in a single piece of legislation, thus ensuring the protection of journalistic material and sources in all matters falling under Quebec's constitutional jurisdiction. With regard to testifying, the proposed rule of evidence is simple. Journalists would have the right to remain silent. They would not be required to answer any questions or to produce any documents relating to the information collected by them as part of their journalistic activities. This immunity would not be absolute, though. It could be lifted when certain conditions are met. 1, the evidence sought is of crucial importance, test of necessity. 2, there is no other reasonable means of obtaining the evidence, test of subsidiarity. And 3, a public interest balancing exercise adapted to civil matters or penal matters. The burden of proof resting at all times with the person requesting that the immunity be lifted. As for seizure in civil matters or warrants in penal matters, the proposed rules would be similar to those found in the federal legislation regarding criminal proceedings. On May 15, 2018, 5 months, probably a record, after the filing of our report, the Quebec Minister of Justice introduced Bill 187, an act to protect the confidentiality of journalistic sources, very similar in substance and in form to the federal legislation. The bill was adopted by a unanimous vote of the National Assembly without any amendments and assented to on June 15, 2018. It is clear that by the summer of 2018, the contours of the protection of the freedom of the press had been made clearer and stronger through the intervention of politicians, both in Ottawa and in Quebec City. What next now for the protection of the freedom of the press? Difficult to predict. Essential to a strong democracy is the capacity of the citizens to make an informed assessment of the issues. Professor Leclerc referred to that a moment ago. Essential to a flow of relevant, accurate, and comprehensive information is the role of the media. The media must be free, active, professional, rigorous, and inquiring. The responsibility of the media is huge, and so is the responsibility of the judiciary in the protection of the freedom of the press. Difficulties arise, as we have seen, when the freedom of the press is competing with other charter rights and freedoms, or, as noted in the Bragg Communications decision, with certain social values. Any balancing of interest exercise must be conducted in a context-specific manner, having regard, of course, to the particular demand at issue. The balancing of conflicting interests and values is always a difficult and delicate exercise. The latitude left with the judges in the exercise of their judgment in such matters is wide. Many of the factors to be put into the scale of these different balancing exercises are relatively vague and open-ended, thus adding to the difficulty and maybe to the lack of predictability. Finally, given the context-specific nature of the balancing exercises, it is easy, it seems to me, to lose sight of the global picture. What is this global picture? A free press is vitally important to the proper functioning of a democratic society. It is our responsibility as a society to keep the freedom of the press alive and well. Any restriction to a free press, be it a publication ban, an exclusion order from a courtroom, a search warrant aimed at media premises, or any judicial authorization or order aimed at a media or at a journalist and related to his or her journalistic activities, must be seen as something exceptional and dealt with as such. This is the global picture that judges must have in mind when the freedom of the press is at stake, and this despite the context-specific manner in which they must conduct the balancing of conflicting interests and values exercises. The journey to today's protection of the freedom of the press in Canada has been everything but a quiet one. Similar, though, I suppose, to that leading to the protection of all other rights or freedoms guaranteed under the Charter. A journey akin to a relay race, the baton being first with the judiciary, then with the elected institutions, and now back to the judiciary. Restricting the freedom of the press and the gathering and dissemination of information is restricting the right of the public to information. Each such restriction theoretically constitutes a potential threat to democracy, the government by the people. These restrictions may well be justified, but we have to always remind ourselves of the potential threat they represent, one at a time and cumulatively. Time to conclude. I began my presentation with the words of a journalist, Christiane Amanpour. I built the core of my presentation with the words of judges, especially judges from the Supreme Court of Canada. I find it appropriate now to conclude with the words of a politician. Those of the 44th President of the United States, Barack Obama. You're not surprised that I picked him instead of number 45. In a lecture delivered in Johannesburg, South Africa, on July 17, 2018, to commemorate the 100th anniversary of Nelson Mandela's birth. And I quote, "Democracy is not just about who has the most votes. It's also about the civic culture that we build that makes democracy work. Democracy depends on strong institutions, and it's about minority rights and checks and balances and freedom of speech and freedom of expression and a free press and the right to protest and petition the government and an independent judiciary and everybody having to follow the law. And as with the denial of rights, the denial of facts runs counter to democracy. It could be its undoing, which is why we must zealously protect independent media, and we have to guard against the tendency for social media to become purely a platform for spectacle, outrage, or disinformation. End of quotation. All of this is, I think, food for thought for years to come. Thank you. Merci beaucoup de votre attention.